peace and tranquility of the island, and the uniting and knitting together of their hearts of all persons and estates within the same, in true Christian love and charity, one towards another, through Jesus Christ our Lord. Amen.
Morning, all, and this Honorable Senate for Friday, the 21st of April 2023, is called to order. Before we begin the business of the day, a number of our members are online and seek the permission of the Honorable Senate members present to join by Zoom. So I think that we have Senator Webby and Senator Morris and Senator Allen. Senator Morris, Dr. Morris, I'm not sure. Welcome members on Zoom, and may I have the permission of the membership for them so to join? Those in favor? Thank you very much. Before we commence, I ask the Senate to take note of the passing of former Chief Justice Mr. Lindsey Wolf. Mr. Wolf was called to the bar in Lincoln's Inn and served on the private bar for many years before joining the judiciary. He hailed from, if my memory serves me correctly, he had some connection to the parish of St. James. He joined the judiciary and became the Chief Justice in 1996, and he served in that capacity until 2007. He is someone who has certainly made a mark on the judiciary in a wider sense, and in the legal profession, and on the precedent, because he did in fact serve in the Court of Appeal and was participant in a number of very important judgments. I asked the Senate to permit the clerk to write to his family, indicating our gratitude for his service to this country and offering our condolences, in particular to his daughter, her ladyship, Ms. Simone Wolf-Rees, who has followed in his footsteps and is now a judge of the Supreme Court. So the clerk, with your leave, will write expressing the condolences of the Senate, but equally important, recognizing the service to this Jamaica through the judiciary. May his soul rest in peace. Statements by ministers. Beg your pardon? Announcements.
Laid on the table of the Senate today are the following. Reports of investigations into the failure of the following 44 employees of the Transport Authority to file statutory declarations with the Integrity Commission. Mrs. Travail Miller.
I'm sorry, Madam.
Tashana.
I don't think that is necessary to read out all the names. We have the reports.
The reports are laid on the table, and the 44 persons are, as indicated, are incorporated in the 44 reports, and these will be uploaded to our website and available to members of this Honorable Senate and members of the public. Also laid on the table of the House today, on the table of the Senate today, are Ministry Paper number 38, 39, 40, 41, 42, 43, and 44 respectively, under the Law Reform Zones of Special Operations, Special Security and Community Development Measures Act 2017 in respect of extension of period of operation number 2, Order 2023, and their respective resolutions for the following zones: the Law Reform Zones of Special Operations, Special Security and Community Development Measures for the Savile and Lamar Zone, the Greenwich Town Zone, the Mount Salem Community Zones, the Augustown Zone, Parade Gardens Zone, and the Norwood Community Zone. And the Denham Town Community Zone, and Ministry Paper number 45, titled Annual Reports on Audited Financial Statement of the Jamaica Agricultural Society for the year ended March 31, 2019. The Annual Report on Audited Financial Statement of the National Housing Trust for the period April 1, 2021 to March 31, 2022. Annual Report and Statements of Account of the Bank of Jamaica for the year ended December 31, 2022. Annual Report of the Exim-Import Bank of Jamaica for the financial year 2021-2022. And the Jamaica Civil Service Establishment General Order 2023 under the Civil Service Establishment Act.
Thank you, Madam Clerk. Bills brought from the Honorable House of Representatives. Petitions, papers, reports from committees, notices of motions given orally, questions and answers to questions. I'm sorry, notices of motions given orally. Thank you. Senator Hill, I recognize you from a seat other than your own.
Thank you, Mr. President. And, Mr. President, I beg to give notice that the next meeting of the Senate, I will move, be it resolved that, notwithstanding Standing Order number 73-1, this Honorable Senate appoint a select committee comprising of the following members: Senators Shireen Golden Campbell, Kevin Gill, Ransford Brem, Sophia Longmore, Lambert Brown, and Sophia Fraser Binns, to sit jointly with a similar committee appointed by the House of Representatives to consider and report its findings to this Honorable Senate on the bills shortly entitled the Criminal Justice Administration Amendment Act 2023, the Offences Against the Person Amendment Act 2023, and the Child Care and Protection Amendment Act 2023. Mr. President, I further beg to give notice that at a later stage today, I will move for the suspension of the standing orders to enable me to take this motion.
Thank you very much, Minister. Questions and answers to questions. Motions that may be made at the commencement of public business requiring notice. Motions relating to the sitting of the Senate. Motions for leave to introduce bills. Presentation of bills without the leave of the Senate first obtained. Public business. Minister.
Mr. President, I beg for the recommittal of the item mentioned on the announcements.
Members would have heard the question, that is to say, the recommittal of the item announcements. Those in favor? Against?
Also laid on the table of the House today are 1. Annual report of the Firearm Licensing Authority for the period April 1, 2018 to March 31, 2019. And the indication of ruling regarding submission of reports of investigations conducted pursuant to Section 33 of the Integrity Commission Act in the failures of 44 employees of the Transport Authority to file statutory deductions with the Integrity Commission. And the ruling will also be uploaded to the website.
Thank you very much. Minister.
Please excuse me.
Yes, I noticed that.
Yes.
Statutory declaration and deduction.
Should be failure of the following, the 44 employees to file statutory declarations with the Integrity Commission.
Thank you for pointing out that, Senator Bunting. Minister.
Mr. President, I now move for the suspension of the standing orders to enable us to take the motion, notice of which I gave earlier, and I'm just asking for it to be approved, Mr. President.
Members should have heard the question. Those in favor?
President, just a concern. Minister, I heard you read 4 names from the government side and 2 from our side. Or was it an error when you said Sapphire and then you went to Liber Beans? Because the normal practice is 3 from the government side and 2 from the opposition. So if you're going to go to 4, I would recommend that for balance there be 3 from the opposition side, not 2. Or you reduce your government side to 3 and 2. That has been the practice over time in the Senate, and I don't think we should depart from it to go to 4-2. The numbers in the Senate has not changed. It may have changed in the other place, but it hasn't changed in the Senate.
I acted on advice. I will take advice. 1 second.
You know, in my recollection is that the number really varies. You know, I've seen 4-2, I've seen 2-1, 3-2.
I would not debate what may have happened in the past, but the advice that I have is that 4-2 is balanced and is acceptable under the arrangements in the Senate.
Chairman, I beseech the minister to add another opposition person to the list. Our views and the views of the minority. It's important to be
Senator
heard.
Brown, what I'm going to suggest you, I have noted the request, and I think that Senator Hill can make the relevant request for the next meeting.
I'd be pleased to hear their suggestion, Mr. President, with your permission, and so I wait for it.
In fact, the clerk has indicated that he could actually do it now, but we'll just, out of an abundance of caution, he can do it.
We could add the Deputy Leader of Opposition Business, Senator Scott Motley.
Okay, you can do that. Thank you. Next order of business. Sorry.
Thank you, Leader of the Opposition Business, and we will ask, I'll ask the clerk to make sure we amend it and add Senator Scott Motley as you have submitted. Thank you very much.
Thank you very much. Those in favor? Aye. Against? Next order of business, Minister.
Mr. President, I seek to conclude the debate on the motion that it be approved.
Yes, I put the motion that concerning the committee, Senator. Yeah, it's amended and approved, correct? Yes, it's amended and approved. So you're going to take the National Compliance and Regulation Authority Act.
Exactly, Mr. President. Thank you so much. I was just making sure. That's exactly what we're going to do. Mr. President, Cabinet Decision Number 2715, dated July 13, 2015, gave approval for the Standards Council of Jamaica to delegate the regulatory functions of the Bureau of Standards of Jamaica, the BSJ, to an administratively created body called the National Compliance and Regulatory Authority. We will use NCRA as the acronym for that authority. NCRA, not NRCA. You're used to the NRCA, it's NCRA. The rationale for this separation of the regulatory functions from the BSJ was that the combination of the BSJ's responsibility, Mr. President, for setting and regulating standards hinders the effective implementation of the World Trade Organization Technical Barriers to Trade Agreement, that's the WTO/TBT, as there was an inherent conflict of interest in the BSJ's organizational structure. The WTO/TBT agreement aims to ensure that the technical regulations, standards, and conformity assessment procedures are non-discriminatory and do not create unnecessary obstacles to trade. The conflict concerns stemmed from the fact that the BSJ performed conformity assessments and set standards and was also required to regulate the standards that it sets. Mr. President, even from this brief preamble, it's very clear that a great deal of work has had to be done since 2015. And I'd just like to commend the legal team from the ministry who are here, led by Mrs. Yvette Sutherland-Reed, people from the Attorney General's chambers who have worked very hard in this back and forth. The SG, her area has been, Solicitor General's chambers also have been very helpful and at work. They've done a whole bunch. I've looked at what we've done in just about a year. Special economic zones, companies amendments, a whole bunch of work has been done. Segregated accounts, and I want to thank the staff who are there today. We won't even talk about the regulations. A lot more work has been done, but thank them very much. My PS, who has organized this, and the others who have worked on it. Upon the review of the administrative arrangements being discharged by the NCRA, Mr. President, it was determined by the Andrew Holness administration that there was a need for the establishment of an independent regulatory authority, which would facilitate the total separation of the regulatory functions from the BSJ and permanently address the conflict of interest considerations and incompatibility with Jamaica's obligation under the WTO/TBT agreement. Consequently, Mr. President, by Cabinet Decision Number 918, dated March 12, 2018, Cabinet gave approval for the National Compliance and Regulatory Authority to be established as a statutory body having the regulatory functions previously discharged by the BSJ. The bill reflects this decision. As such, Mr. President, principal objects of this bill are: A, establish a body to perform regulatory functions previously performed by the Bureau of Standards. B, regulate weighing and measuring devices for trade and for purposes incidental to or connected with the foregoing purposes. And C, Mr. President, is to regulate and enforce the processes and practices connected with the manufacture, production, and treatment of commodities for which a compulsory standard specification or technical regulation has been declared and intended for products for 1, exports, 2, sale in the domestic market, and 3, purposes incidental to or connected with the foregoing purposes. The bill, Mr. President. Part 1, preliminary. Clause 1, short title and commencement. This clause states the name of the Act and stipulates that it will come into operation only after an appointment date notice is published in the Gazette by the Minister. Clause 2. The clause defines certain key terms used throughout the bill, such as authority, which means the National Compliance and Regulatory Authority established under Section 4, commodity, which means any article, product, or thing which is the subject of trade or commerce. Compulsory standard specification, Mr. President, means a standard specification which has been so declared by order by the Minister pursuant to Section 7 of the Standards Act. Technical regulations, Mr. President, means a document, A, which lays down material, product, and production methods, the services, characteristics, or their related processes, and includes the applicable administrative provisions with which economic activities must comply, and B, which is in keeping with the mandatory compliance of the World Trade Organization Barriers to Trade Agreement, WTO/TBT. Clause 3, Mr. President, the objects of Act. This clause specifies the principal objectives of the Act, which are to A, establish a body which will perform regulatory functions previously performed by the Bureau of Standards. B, regulate weighing and measuring devices for trade purposes incidental to the duty to regulate, and C, regulate and enforce the processes and practices connected to the manufacture, production, and treatment of the commodities where a compulsory standard specification has been declared. Part 2, Mr. President, deals with the establishment and functions of the authority. Clause 4 under this part deals with the establishment of the National Compliance and Regulatory Authority, the NCRA. This clause, Mr. President, stipulates that for purposes of this Act, the Standards Act, the Processed Food Act, the Weights and Measures Act, and any other relevant enactment, there is established a body corporate to be known as the National Compliance and Regulatory Authority, which Section 28 of the Interpretation Act applies. The clause also speaks to the provisions of the first schedule, which shall have effect in relation to the financial provisions of the authority. Clause 5 deals with the functions of the authority, Mr. President, and in this clause, the functions and the role of the authority are carefully detailed. This includes, but is not limited to, Mr. President, A, regulating, monitoring, and enforcing compulsory standard specifications or technical regulations in relation to commodities. B, inspect commodities at port of entry and in the domestic market. C, assist, consult, or otherwise engage with the regulated industries and their commodities. D, Mr. President, deals with the issuing of certificates of registration. E, requests any necessary documentation to ensure compliance with compulsory standard specifications and technical regulations. F, Mr. President, deals with the inspection operations or premises, inspect operations on premises or investigate complaints of non-compliance with specifications or regulations in respect to commodities. This clause, Mr. President, also stipulates that the authority may, in performing the above functions, establish a procedure and develop, implement, and monitor plans and programs relating to commodities. B, that it should charge fees for services provided. C, consult with other agencies of government that carry out functions in relation to standard specifications, compulsory standard specification, and the Jamaican reference standards as outlined in Section 4 of the Weights and Measures Act. And D, Mr. President, do such other things as may be expedient or necessary for the proper performance of the authority's function under this Act or any other relevant enactment. Clause 6, Mr. President, deals with the establishment of the Board of Directors. This clause establishes a Board of Directors of the authority. This clause also gives effect to the provisions within the second schedule as it relates to the constitution and procedures of the board. Clause 7 deals with the functions of the board, Mr. President. This clause identifies the responsibilities of the board as it relates to the policy, strategic direction, and governance of the authority. The clause also identifies the specific role of the board in exercise of their functions, which include but are not limited to A, monitoring the administrative operations of the authority, advise the minister on matter of general policy as it relates to the management, development, and encouragement of an efficient regulated commodities industry. C, ensure management and receipt of funds allocated to the authority. And D, do all other things as the board reasonably deemed necessary in carrying out the functions of the board. This is a very important clause, Mr. President, because up till now there was sort of an advisory board, advisory committee that did not have the authority that this clause number 7 does now give to the board, which is what a board should do. So the NCRA was operating in sort of limbo land, and that's part of what we've heard before in some of the issues we've had raised. This clarifies and puts structure to that rather amorphous arrangement. Clause 8, Mr. President. The minister may give direction to the board, which is how policy is conveyed. This clause establishes the premise for the minister to give general directions as to the policy to be followed by the board in the performance of their functions. That's broad, well-known, understood. Minister doesn't interfere, but he takes policy direction from cabinet and takes it to the board. Clause 9, Mr. President, deals with the appointment of the chief executive officer. This clause provides that the board shall appoint a chief executive officer. The clause also outlines the minimum requirements for the selection of the chief executive officer, which includes, but clearly is not totally complete, is not exhaustive. A, possessing the requisite knowledge, skill, and experience which are necessary for the intended functions to be carried out by that individual. B, the ability to exercise competence, diligence, and sound judgment in fulfilling these functions. C, appears to the board to be a person of integrity. And D, has been has rather not been convicted of any offense of any moral turpitude. Clause 10, Mr. President, deals with the functions of the Chief Executive Officer. This clause provides for the responsibilities of the Chief Executive Officer, which includes, but again clearly not exhaustive, A, a properly carrying out of this Act and day-to-day management of the authority. B, overall planning, coordination and organization of the activities of the authority. C, development of the programs and performance targets for the approval of the board. Preparation, Mr. President, is D, and preparation submission of the strategic, corporate and other plans for the board's approval. And E is the performance of such other functions as are conferred by the board or under this Act or any other enactment. Clearly, that omnibus clause in E gives the board a wide range of control and monitoring. Clause 11, Mr. President, deals with the administration relating to the appointment of officers and employees. This clause provides for the appointment of officers and employees. The clause stipulates that for the purpose of carrying out the provisions of this Act, the Chief Executive Officer, after consultation with the approval of the board, may appoint and employ to any office in the authority such other officers and employees as such remuneration and on such terms and conditions as the authority considers necessary. Additionally, Mr. President, this clause also makes it mandatory for the Chief Executive Officer to consult with and receive the approval of the board in establishing the qualifications for the various offices within the authority. Again, Mr. President, you will notice that these clauses from Clause 7 really are dealing with the proper governance of the NCRA, which, as I said, until now has been in relative limbo. Clause 12, Mr. President, deals with the pension, gratuities, and other retiring benefits. This clause provides that the authority will be able to enter into arrangements in the respect of the above-mentioned schemes and make regulations in relation to same for the benefit of its officers and employees. Such arrangements or regulations may include provisions for the grant of the benefits to the dependents and the legal personal representatives of such officers and employees. Clause 13, Mr. President, deals with the obligations of secrecy. This clause states the requirement for every person who obtains information relating to the functions of the authority to regard and deal with such as secret and confidential. It's very important. You're dealing with food, you're dealing with medicines, you're dealing with people's lives, and people who work in the NCRA should absolutely know that the information that they're privileged to handle must remain privileged and must not be disclosed to people who are like when I used to write for any newspaper. I'd love to get information, but if I call you, you can't give me the information. It must be kept there because it's confidential. This clause extends this obligation of secrecy to any individual to whom information relating to the authority is conveyed. Further, Mr. President, this clause sets out the policy if found in contravention with the obligation of secrecy. Clause 14 deals with indemnity, Mr. President, and it says this clause protects an employee of the authority or members of the board from any action or suit for anything done in good faith in the execution of the Act. If we're asking for that kind of professionalism and secrecy, then clearly indemnity is part of the deal. Excuse me. Clause 15 deals with the appointment, Mr. President, of inspectors. This clause allows for the appointment of inspectors by the authority for the efficient discharge of the functions conferred or imposed on inspectors by the Act. It further requires the issuance of a certificate of appointment and an indemnification card to each inspector, and for a notice of appointment to be published in the Gazette. Not everybody can just get up and inspect. You must follow a proper and particular procedure. Clause 16 deals with the functions of inspectors, Mr. President, and it says this clause stipulates the functions of each inspector, which includes but are not limited to A, entering and inspecting premises, B, establish and maintain records of such matters as may be specified by the authority, C, report generally to the authority, D, perform any other functions as may be described or prescribed or may be authorized by the authority under the Act or any other relevant enactment. And E, Mr. President, provide guidance pertaining to the manufacturing or processing of commodities. We get to Part 3, Mr. President, and Clause 17, which deals with offenses. This clause outlines the circumstances in which a person commits an offense, which include but are not limited to if that person, A, uses for trading any measurement unit which is not provided for in the Weights and Measures Act, B, uses the carat metric except unless trading in pearls or precious stones, C, uses the ounce troy metric except unless trading in articles made of gold, silver, or other precious metals, D, assaults or obstructs any inspector in the course of his duties, E, bribes or attempts to bribe an inspector, F, being inspector or other employed personnel to the authority accepts a bribe, and G, Mr. President, contravenes a provision of the Act. This clause provides that subparagraphs A to C, offenses listed above, shall not apply to transactions in connection to the export of goods to a country which uses the restricted units of measurement. The clause outlines criminal sanctions and penalties for contravention. Additionally, Mr. President, any measure or weight used or in the person's possession for use in contravention of A to C above shall be liable to be forfeited. The clause also provides and gives the authority the power to investigate and institute the necessary protection in relation to any applicable offense. That should be investigate and institute the necessary prosecution in relation to any applicable offense. Part 4, Mr. President, deals with the appeal. And Clause 18 under Part 4 says that the National Compliance and Regulatory Authority Appeal Tribunal. This clause establishes the tribunal for their purpose. The clause also gives effect to the provisions within the third schedule as it relates to the constitution and proceedings of the tribunal. This clause further allows, Mr. President, the minister to appoint at least 3 members of the tribunal to facilitate the inclusion of the requisite competence as necessary. The regulations, of course, will give further guidance and clarity to this clause. Clause 19, Mr. President, deals with appeal. This clause outlines the premise and the time frame by which an appeal can be made to the tribunal by an aggrieved person. This clause sets out the procedure for making such an appeal to the authority. This clause also sets out the duties of the authority in relation to a pending appeal. And Part 5, Mr. President, deals with the miscellaneous provisions, and Clause 20 is the first in that part, and that deals with the amendment of monetary penalties by order. This clause outlines the authorization for an amendment of any monetary penalty within this Act by the Minister after consultation with the Minister responsible for finance. Clause 21, regulations, Mr. President. This clause provides that the Minister may make regulations for such matters as may be necessary or expedient for the purposes of this Act. These regulations may provide for a. The inspection and verification of commodities, processes, and practices, and the entry upon premises to inspect and verify these commodities. B. The condemnation, seizure, detention, and disposal of any commodity or class of commodities deemed in contravention of this Act. The clause also establishes, Mr. President, the mechanism for the regulations to prescribe greater penalties than those specified within the Act, notwithstanding Section 29 of the Interpretation Act. And as is my practice, Mr. President, I would expect these regulations, and I'm looking straight at Mrs. Sutherland Reid, to be out very, very soon. An Act means nothing without the regulations, so I need them fast. The clause also, Clause 2022, consequential amendments. This clause identifies the consequential amendments found in the 5th schedule. Part 6, the existing license. In Clause 23, Mr. President, the matter of existing license or other authority is dealt with, and this clause confirms the continuation of a license or authorization throughout its given period until expiry thereof, notwithstanding the enactment of the provisions of this Act. Clearly, we don't want to disturb or disrupt business, so this clause is necessary. In the 1st schedule, Mr. President, that deals with the financial provisions, accounts, and reports. This schedule lists the fund and resources of the authority as referred to in Section 4 of the bill, which consists of A. Such sums to be placed at the disposal of the authority by Parliament. B. All other sums and other property which becomes payable or is vested in the authority through or by which the authority is to function. This schedule also provides, Mr. President, among other things, for the power of the authority to invest and borrow sums required by the authority with the approval of the Minister responsible for finance and to provide an annual report to the Minister. 2nd schedule, the Constitution and procedures of Board of Directors of the authority. Mr. President, this schedule lists, among other things, the constitution of the board, that is, 1 ex officio member and 12 others. It provides for the appointment of the Board of Directors, Chairman of and Deputy Chairman, sorry, and outlines the tenure of office. It also provides for revocations and resignation of appointment of a member of the board. The 3rd schedule of the National Compliance and Regulatory Authority Appeal Tribunal. Mr. President, this schedule establishes the National Compliance and Regulatory Authority Appeal Tribunal and provides for the constitution of the tribunal, as referred to at Section 18 of the bill. The schedule also provides for the tribunal to regulate its own proceedings. The 4th schedule, Mr. President, Form A and Form B. This schedule provides for Form A, which is the certificate of appointment of inspector, and Form B, which is the identification of inspector as referred to at Section 15 of the bill. The 5th schedule deals with consequential amendments, Mr. President. This schedule provides the relevant consequential amendments to various enactments as provided at Section 22 of the bill. This includes the Processed Food Act, the Standards Act, the Weights and Measures Act, the Bureau of Standards Additional Functions Regulations, the Processed Food Establishment Regulations 1959, the Customs Prohibition of Importation of Goods Order 1991, the Public Health Food Handling Regulations 1998, and the Public Health Tobacco Control Regulations 2013. The amendments mainly address the recognition of the NCRA as opposed to the role of the BSJ. Memorandum and of objects and reasons, the memorandum stipulates the key objective of this act. May it please you, Mr. President.
Thank you, Minister. Senator Brown.
Thank you, Chairman. President, I noted that the Minister didn't call for support for the bill, but maybe
We agreed before. Brown, you need it?
No. President, this bill reflects the government policy in shifting and separating the regulators from being operators. I think one such agency, for example, that begs for this is the National Solid Waste Management Authority, for which I believe at least one board member sits in this House, and there are others. So, in a sense, what is happening here is instead of going full to remove all of those, we're going one by one, it would appear, starting or continuing with this bill before us, the National Compliance and Regulatory Authority Act 2023. Truth is, while this bill was tabled some time ago, we only learned on Wednesday about that it's going to be taken today, and some of our members are not present, would have loved to speak to it, and I'd have wished if we could, after the first set of discussion, allow for a suspension and pick it up. But I have a few comments on sections of the bill. In the entitlement, it deals with to regulate processes and practices connected with the manufacturing, production, processing, and treatment of commodities. At clause 3, at 3C, it deals with exports, sales in the domestic market. But I'm not sensing, President, that this bill is aimed at dealing with importation as well. And that's a big part of our economy. So there's a dispute recently about rice, whether the rice imported was of the proper standard. Would this bill address that? Because it seems to be excluding importation, and would hope that would insert in the bill importation. Certainly, Mr. President, it's a long time since I've dealt with cannabis, but the importation of cannabis and the quality and the impact, would that be captured in this bill? And I'm not sure, as worded, that rice and cannabis and any other such imported products. I've seen in the past funds imported into the country having difficulty, and we've seen agencies recalling product. Talc powder is one such in recent time. Does this bill address importation? And is the government averse to putting in the bill itself the words importation. So it makes it abundantly clear, beyond caution, beyond any doubt, that importation is intended to be part of the responsibility of the National Compliance and Regulatory Authority. And it's interesting that the bill speaks to integrity as the person who must head the agency, because issues of integrity arise and conflict of interest arise every day in the trade relations. We saw it with this imported rice. And so, if you're bringing this bill, we want to make it clear that these issues are going to be part of the mandate of the regulatory authority. We've seen, Minister, complaints about the quality of blocks, concrete blocks, quality of water, coconut water. And therefore, we support the need for an active and robust agency addressing these shortcomings, especially in a country that is subject to earthquake. So that things like concrete block and the quality of it is important. Minister, I'm only regretting that this doesn't cover security guards, because the way we treat them now, we treat them as a commodity. That's the point I'm making. But we're treating these people like commodities now. Less than with dignity. You want to get up, you're rising on that point? Or are you just leaving your seat? So I regret that it doesn't address security guards, because I was at a funeral yesterday of a former JC Old Boy president, and the pastor was lamenting the treatment of security guards. And a congregant came up to me after and said, please, please talk about security guards. I hope I've done a little of that. I'll move on. President Otto Webley, State Management, yeah. It was nice to see Teddy Alexander and all of those boys present yesterday. Yeah. President, I know it's not a KC thing, but it's your 98th anniversary now, am I correct? Or it's 95th? Mr. President, at 9.2, it speaks to the experience of the CEO. At 11.5 on page 9, it speaks to, that is the bill, it speaks to the chief executive officer shall consult with and receive the approval of the board in establishing the qualifications for the various offices within the authority. But it is interesting, Minister Hill, that at 9.2, it doesn't speak to the qualification of the CEO. It says the CEO shall be an individual who possesses the knowledge, skills, and experience who are necessary for the intended function to be carried out by the individual. Is there a reason why there's no qualification required? And having regard for what has happened at the Jamaica Urban Transit Corporation, as shown up in the audit report, could we ask that the qualification be put in? Yes, in the bill, yes. That's what we're debating, the bill. I will, in due course. But I'm saying, if we put possesses the knowledge, why can't we put possess the qualification, skills, and experience? As is in 11.5. That's the point I'm making. At 11.5, we say we want the qualification of people. We can put it in 9.2. Why is there a discrimination between the staff members and the CEO? That there is no qualification requirement. for the CEO, but there's a requirement at the lower level. So I raised that, President, because it strikes me that that's a concern and it would look discriminatory, even though it may not have been intended. I come now to clause 13, and the minister spent some time on clause 13. 13(1)(b) speaks to being bound by the Official Secrets Act. My memory serves me, this is an act that is almost a century old, and it has been the subject of discussion as to whether we should continue to be bound by that act. We have moved a long way with the Access to Information Act, a very robust and a very useful piece. It allows people to know, for example, whether gifts are reported to the Ministry of Finance. What you said, Senator Bunting, you mentioned a number there, 99 US dollars, I see. So, is there any role for access to information under this legislation? Or we're so determined to be so secretive that in the era of transparency, the public is going to be denied knowledge. So I'd love to hear from the minister, what role does access to information play in this? For example, if somebody imports substandard rice and somebody in the media chooses to ask, or a member of the public to access to information, would that be in violation of clause 13?
Yes, that's correctly worded.
And is that the intention? To shut down the need for investigation? So I hope we can agree, Minister, that access to information is allowed in respect to this bill and the overriding desire to go back to the almost century-old Official Secrets Act is not going to be the course we adopt. And so I'd urge you to strengthen this provision with a dose of transparency, suggesting and explicitly stating that this act is subject to the access for information legislation that was passed some time ago. It brings me, President, to part 4 of the Act, clause 18, establishing an appeal tribunal. It's not clear what is the nature of this tribunal, appeal tribunal. Is it going to be a permanent body? Is it going to be an ad hoc body? Because all it says is establish a tribunal. Will that tribunal be required to meet regularly or only when cases are before it? And if it's only when cases are before it, how comes in the Act we say, if you miss 3 meetings, it assumes that it's going to be meeting regularly. It assumes so, because I certainly don't think you're missing 3 meetings of a hearing. And I'd urge some clarification as to the nature of this tribunal. The minister may appoint at least 3. Will this be a body beyond 3? Because it says, if the chairman is absent, then you will add. You can add. Add from new appointments or add from the body of tribunal members. That's not clear. And I'm not sure that that's going to be cleared up by regulations. So the nature of this tribunal is important to state. And that brings me, President, to the approach to appeal tribunals by the government. And by government, I'm not talking party. I'm talking the state. There's appeal tribunals or tribunal which could be concerned in the Ministry of Labor, in the Ministry of Agriculture. For example, I think under the commodity boards, there are appeal tribunals. There's appeal tribunals, I suspect, elsewhere in agriculture. There's appeal tribunal in health. There's consumer appeals tribunal. There's appeals tribunal in the firearm operations, FLA. So there's and then Senator Gill, Senator Rodriguez Campbell, or Campbell Rodriguez and I sit in another place where the issue of appeal tribunal is being contemplated. And it's clear that there are just different appeal tribunals all around the place with different composition and arrangement. And there may be reason for that. But I believe the government ought to pause and study the number of different appeals tribunals and see whether or not a template cannot be established to govern that. So you're in a committee and the committee is saying, what other tribunal does? And of course, in the legal era, there's the role of the JLC. In the medical era, there's others. In accountancy there. So in other words, there's a whole set of tribunals and appeals tribunals that have been set up. But every day we come, we have different approaches to the composition and the approach to be adopted by these tribunals. And I'm calling for maybe a national tribunals and appeal tribunal legislation which save us the need for every bill to be put in a unique appeal tribunal and get the composition right. So this is one of 3 members. It says it shall be chaired by an attorney at law of 10 years experience. So it's saying get somebody who could become a judge. Do we need that for every tribunal? And then in this one it says the minister can replace the chairman under certain circumstances and appoint somebody else. So does that now indicate to us that the commission should, the tribunal should consist of more than one person with 10 years and more legal service? Otherwise, you'd not be able to change that chairman. So is our intention to pack it with lawyers? I'm not clear on that, and I'd appreciate some information. Under that schedule, the 3rd schedule, it is Chairman, President, and page 26. It speaks to the tenure at 5, it speaks to the tenure of members on the committee. And it says the tenure shall not be more than 2 years. So, if the board is, or the tribunal is to be meeting 2 months shy of the 2 years, and Minister Braham goes, Member Braham goes, Senator Braham goes to court to challenge some decision, you might have to wait for a new set of appointments to take up this matter. I don't think there's any magic, Senator Hill, in limiting the tenure to 2 years. There are other tribunals where the tenure has been longer. And maybe you want to consider that, because it certainly looks inefficient to me. And it says members shall be eligible to reappointment. But we saw recently a good faith measure came here, where was it one of your commission hadn't been changed in accordance with the law, and we have had to go for good faith decision. So I'd urge that that be dealt with. I come in closing, President, to clause 8 under the tribunal. The minister may terminate the appointment of any member of the tribunal who, and I go to C, is convicted and sentenced to a term of imprisonment or to death. Minister, you may be convicted for 5 months and you can still sit in this parliament. Is that the intention here? That a member of an appeal tribunal convicted and sentenced to a term of imprisonment for indecent language? You're more likely to be in the tribunal. No, I'm not talking about the membership of the tribunal. I'm talking about the conviction. Which is what I'm talking about. No, I don't think that's what you meant. So let us be clear. What I'm saying here, President, is that this ought not to be just any term of imprisonment. This ought to be a substantive term, 3 years or more. And what if the personal conviction has been expunged? We need to make provision for that in the... It ought not to be. But what this says is that if you were sentenced to a term of imprisonment, so it's going beyond just the conviction. So I'm saying it needs addressing. I do not believe you are comparing any term of imprisonment with death, which is what is in this clause. Maybe you meant life imprisonment, which is comparable to the death sentence. But certainly it cannot be any conviction. Somebody convicted and sentenced to a term of imprisonment for manslaughter, motor or reckless driving, men shouldn't be exempt necessarily from appointment to the appeal tribunal. So I invite you to re-examine the appeal tribunal. And I end by where I started. Maybe a little pause, allowing you to review this and other aspects of the bill. And we come back next time and address it. Those, Minister, would be the humble submissions that I make to you. It's one thing to rush bills through and end up with bad bills, rather than to pause, get it right, so we make bills that make sense. President, somebody brought to my attention the other day that if you are carrying your legal books in your private car. Your legal documents, books. Just as my cousin is carrying his walker in his private car. Under the current regulations, without a green plate, you may have committed an offense under the Road Traffic Act. I do not think that's what we intended as a parliament. Which is why I'm making the point. Which is why I'm making the point now. Which is why I didn't vote on it. Which is why I'm making the point now. That a pause may allow us to avoid that mistake. Or the child seat mistake. Why are you putting me? You have a vice vote? You have a vice vote? Which is why I often say, President, record me as opposed to that. So, whether we voted for it, it is lessons that we are learning. That, is to get legislation through. And nothing is wrong with moving quickly on legislation. We may be making some bad decisions. And this is one of them. So, while we're not opposed to the policy direction, the specifics of this legislation, in light of the caution of the President to me that I vote for, I wish to say I would not vote for in this bill, preventing somebody from sitting on an appeal tribunal for minor offenses for which they are sentenced to imprisonment. Sometimes they're sentenced to imprisonment because they can't pay the fine. Yes, because it is not his pocket that will determine the decision, but his mind. Well, President, I hope that any government will have regard for the fact that members of such a tribunal should be people of impeccable integrity, people who are devoid of conflicts of interest. No. The poor and the rich man shouldn't be divided. I am voting for Lazarus. Yes, that man who sat at the gate. Right, Ronnie? Lazarus at the poor man at the rich man gate. So I'm saying, I am for the Lazaruses of this world to be able to sit at the high table. I am for the lady with leper, or the leper, to touch the garment, the edge of the garment of the Savior. I am in my Bible today, because I believe my Bible will lead Minister Gill in the right direction. So I am suggesting, don't call who? I'm not going to be drawn by my friend. I'm not going to be drawn by my friend, Senator Samuel. But suffice it to say, pause. Let's take a second look at some of these things in the bill and come back. There is no rush because this bill will be inoperable. Did the minister say, Senator Bounty, the bill is nothing without the regulations. So until the regulations come, drafted or not, until it comes, this bill can be put in place. So, and it is for a date to be announced by the minister, published in the Gazette. There's no ease for this. We ask for a pause for a week. Look at the concerns I've raised and others may raise, and we come back and complete it. And you'll be happy then to get our full support because the errors of ACE would have been avoided, as we have seen in other bills before us. And of course, it would have allowed the Attorney General to at least tell us as a chamber how many tribunals exist in the government service, appeal tribunal, and to look at them and to see whether or not we can't have commonality in the templates that guide us. May it please you, Mr. President.
Minister, you're speaking. Thank you very much, Senator Brown. Senator Gill.
Thank you, President. President, you know, it appears in the last few sittings, I have been speaking immediately after Senator Brown. And in my presentation, I am going to, first of all, the area in relation to the tribunal is one that we both would have shared concerns over, and we would have requested information in relation to the examining the number of tribunals that are operating, and for us to make a determination if it requires some level of consistency in terms of approach. Senator Brown has asked for what appears to be a delay in the passage of this legislation, or a pause, using his term. But the pause, in fact, is a delay. This legislation, President, has been long in coming. Matter of fact, I stand here because I speak on behalf of the employees of the NCRA who are members of the Bustamante Industrial Trade Union and who so happen to be directly my members as the representative. And when I say it's long in coming, I recall in my understanding in July 2015, the Cabinet gave approval for the separation of the regulatory division of the BSJ. The NCRA became operational in January of 2016. And when the concerns were raised, the union would have written to the management of the BSJ advising that there's no legislation in place for the operation to take effect. And concerns were being raised by our members. And I have been one to have been monitoring. Somebody had said to me, Minister Hill, I was stalking the passage of this legislation. But I would want to advisedly prefer to use the term monitoring. And so in 2018, right, and so in 2018, the Cabinet gave approval for the NCRA to be established in law. President, the establishment of this regulatory authority, as a separate body charged with carrying out the regulatory functions is a positive step towards ensuring that regulatory functions are carried out effectively without a conflict of interest. And so this separation of the regulatory functions from the BSJ is necessary to address the conflict of interest that arises when a single body performs conformity assessments and set standards and is also required to regulate the standards that it sets. And so this can lead to a situation, Mr. President, where the Bureau may prioritize its own interests over those of the consumers or the interests it meant to regulate. And by establishing this as a separate body, the government is ensuring that regulatory functions are carried out in an impartial and transparent manner. Mr. President, the NCRA will solely focus on enforcing regulations and standards, ensuring that businesses comply with the regulations and protecting the consumers from substandard products and services. And this is very important. So this legislation, sir, is helping to clarify the roles and responsibilities of each organization, making it easier for business to understand and comply with regulations. And it will also ensure that the standards and regulations are regularly reviewed and updated, and that they are consistent with international best practices. Mr. President, those are very critical objectives of what is being proposed in the legislation. And so, overall, the establishment of the NCRA as a separate body charged with carrying out regulatory functions is a positive step in ensuring that regulatory functions are not only carried out effectively, but they are carried out transparently without conflict of interest. And I believe, Mr. President, that this will have a positive impact on businesses, consumers, and the economy as a whole. Mr. President, Senator Brown, in his representation, would have spoken about made an indication in clause 9.2. That's the clause 9.2 speaks to the chief executive officer shall be an individual who possess the knowledge, skills, and experience which are necessary for the intended functions to be carried out by the individual. And B, is able to exercise competency, diligence, and sound judgment in fulfilling these functions. C, appears to the board to be a person of integrity. And D, has not been convicted of an offense involving fraud, dishonesty, and moral turpitude. Now, what Senator Brown is asking, in conjunction with what is in 11.5, is something that I've not seen in legislations. And the legislation don't speak to the person. It speaks to the qualifications and experience that any individual that has been employed or will be employed must possess. And so I'm of the firm view that there is no question about the incumbent, but intentions in terms of what is crafted in the legislation is clear. Now, my understanding with 11.5 is that 5 is saying the chief executive officer shall consult with and receive the approval of the board in establishing the qualifications of the various offices within the authority. So here is the situation now where there's the intention to build out the capacity within the authority. And in so doing, the prudent and proper thing to do is to have the consultation with the team, have the consultation with the board to be able to determine what are the composite skill sets, functional capabilities, and qualifications that are going to be required to carry out this function. And so, that is the role and function of a CEO, Mr. President, in building the capacity of the authority. So they don't need to be infused in terms of what Senator Brown is suggesting. The other area that Senator Brown spoke about was, whether or not the importation of rice is conforming to proper inspection. Now, I looked at Clause 5, the functions of the authority. And it speaks to the functions of the authority that regulate, monitor, enforce compulsory standards, specifications, or technical regulations in relation to the process and practice connected with the manufacture, production, and processing and treatment of commodities. But I think Senator Brown was more referring to what I see in C. Inspect commodities as ports of entry and in the domestic market. I think if you turned your attention to that, it may very well treat with the concerns that you have raised. No, but that's the intention of the legislation. But it was stated, unless, Senator Brown, you were reading it in a different way. Mr. President, this organization, this agency that has been created to regulate the processes and practice connected with manufacturing, production, processing, and treatment of commodities, for which a compulsory standard and specification or a technical regulation is necessary. It's an awesome responsibility. The NCRA plays a critical role, sir, in ensuring that businesses comply with standards and regulations set by the government. And so the agency is aimed at protecting consumers by ensuring that the products and services are safe and of high quality. And so the consumers want to be assured that when they purchase goods, they are of a certain standard that meets the required specification. And so this is an awesome responsibility. Mr. President, it calls on the entity, however, to have the resources necessary to carry out its duties. And this includes having enough staff, equipment, and funding to effectively regulate and monitor businesses. The agency, sir, must also have the authority to enforce the regulations and standards. What is important, however, in my mind, President and members, is that in order to effectively carry out this work, the NCRA has to work closely with businesses and stakeholders to develop and implement standards and regulations. The collaboration is going to be important, to be working with businesses to inspire that level of confidence with the businesses in terms of which you are engaging with, to ensure that they not only in the first instance comply, but as standards improve, their standards ought to also be updated for improvement. And so the collaboration is going to be important. Now, President, that's an awesome workload. It's not an easy workload for the employees. And the NCRA team members are already working at full capacity. Mr. President, in the Inspectorate Division, there are over 30 inspectors and 4 inspector assistants. And inspectors are assigned to conduct, food inspection, other areas of inspections. You hear about, Senator Brown would have spoken about the blocks, product standards, imported appliances, imported construction items, the accuracy and weighting and measuring of devices that is used in trade and those used for the importation and the quality of petroleum imports. Mr. President, in the Food Inspectorate alone, there's over 800 and odd registered establishments. And then you have the construction industry and any other entity that provides services in terms of trade. Over 30 are the inspectors. Over 30 are the inspectors of committed technical staff with avid experience in terms of being on the job up to 5 years. And we commend them, sir, for staying with the organization and continuing to support and providing the service. But, Mr. President, the organization, given the regulatory mandate, need to acquire more people because those that are there are overworked, are burdened. And based on the mandate of the organization and the increased need for regulatory activities, the team is required to work extended working hours. And Mr. President, this can create burnt out. And so what I want to implore is that there ought to be a strategic need to support an expansion of the structure that calls for the required support in terms of expansion of not only the inspectors, but also the assistant administrative support to those inspectors. Mr. President, in this day, when we're talking about not only building the capacity, but if we're going to speak about building the efficiency, and there has to be that greater turnaround time in ensuring that standards are met, ensuring that inspections take place, there has to be a greater investment in technology. And so, Minister, that would be, and I know you are one who pursues efficiency, and I'm imploring you, sir, so that you can, as part of this organization mandate, to support that need for improvement in technology and investment in such technology. Mr. President, I believe what we are doing here today is long in coming. It is required. The NCRA should not be operating outside of the mandate of a legislation. And so, without haste, sir, I'm in support of this legislation. I have been monitoring it, and I will continue to support and consult with the NCRA in the manner that we have been doing. The union we have established protocols of quarterly engagements, looking at not issues or disputes, but how we can improve the efficiency of the organization through a consultative mechanism that involves the involvement of the workers. And it has been working very well, sir. And we will continue. After the passing of this legislation, Minister, you may hear from us in terms of other recommendations going forward, coming from the workforce, that speaks through the voice of this union. We support the legislation. Don't worry about the wage increase. We know how we can deal with that effectively. We're not coming into this parliament to talk about how government threaten and bad up unions, because no union is worth their salt if they allow any government to bad them up. And the BITU is not one of such unions that expose itself to any badness. May it please you, Mr. President.
Mr. President.
1 minute, Senator Hill. Thank you, Senator Gill. Yes, Minister.
Mr. President, I want to thank my colleagues for their participation in the submission. And I'd just like to make a few comments before I ask for the second reading of the bill. The first matter, Mr. President, is that we've had to pass many bills through this chamber and the lower chamber in what would reasonably be called in haste. This, though, Mr. President, is not one of them. I tabled this bill on the 17th of March. That's 5 weeks ago. Given how some bills have to be moved fast, I think my friends on the other side would say that's a very long time. So I'm not going to, I think the pause is a request that is subjective and I respect, but I hope that my partner on the other side, my colleague on the other side will understand when I say asking for a pause after 5 weeks is a bit much. I would rather, though, turn to something that is more urgent that he raised, Senator Brown, that is, and that's the issue of, you know, there's nothing in there about imports. But there is, Mr. President. But there it is, Mr. President. If we go to, to Clause 3 and Section C of that clause, Item 2, and my colleague and leader on this side, Senator Gill, addressed it, but I want to just emphasize that it says, Clause C2, sale in the domestic market. Now, that is such an omnibus clause, Mr. President, that there is no way you can exclude imports from that. Anything that's sold in the domestic market has to be dealt with here. And I think, Mr. President, that adequately addresses that issue. There's another issue, though, a couple of issues that my colleague, Senator Brown, raised that I'm actually happy he raised. One was the issue of rice. He mentioned the blocks and coconut water. Let's take the issue of rice. Mr. President, there are 137 importers of rice in this country. When the issue was raised, as I would normally do, and as I always do, everybody must know that, anytime there's an issue, I go to my technocrats first. I might very well not listen to what they say, overrule. Very often, most of the times, I listen and agree. But how can I have people of that experience very often and technical ability and don't ask them? So you know what I did? I called in the entire NCRA team with my permanent secretary and with the chief technical director and some of the board members, and I asked the head of compliance at NCRA. He has a PhD in his subject, and he has been working at the NCRA for 17 years, Dr. Wendell Richards. So I look at him, I sit down on the table, I look at him, Dr. Richards, how many people you have importing rice? Because the way you read it in the paper, it was only one. I mean, Mr. President, I was amazed. I was amazed. You would think it's only one. Then I went on. I said, Dr. Richards, Dr. Wendell Richards, how many people of these importers breach at some time or the other? He said every single one. I didn't believe I heard him. Because all of us know many of the big ones. So I couldn't believe my ears. So I asked him again. I said, this is what I asked you, did you hear? He said, yes, and this is what I answered. This is what I'm telling you. So he said, everybody breached at some time. What's a breach? Do you have the right number of grains or that not mashed? But none of them breached the food protocol. And there was no plastic rice. There's no plastic in there, no foot, all, Mr. President, he said to me, all the rice come from the same place. All the rice come from the same place. So you know what? I found out in those discussions that we don't have any. I said, then how do you know the difference? Do you have them A, B, C, and D? That's what they're supposed to have. Mr. President, I'm telling you, it's an agency in my ministry. This is why I'm getting this legislation done. We never even ask the people who send the supply of rice to grade them by A, B, C, and D. Now it's being done. I had the BSJ go in and change the standard so that coming out of that, but what came out was this. That the gentleman who was named, and his name happens to be Charles Tufton, is the only one that was, you would begin to believe that he was the only importer of rice. He had to go and write and defend himself in the newspaper. Everybody breached. Everybody is now going to be fixed. And the issue of rice, part of why we're doing the NCRA arrangement is to make sure that you separate the people who do the testing from the people who do the operations. So I'm saying to you, Mr. President, and the issue of blocks, yes, we've gone, I'm not tired over here, sir. Not tired. So the issue of blocks, we're making, again, standards weren't clear, weren't being supported, they didn't have enough staff, we're buying new equipment, new technology going in. Once I get in there, Senator, Mr. President, once I get in there, I'm going to make sure that they get them done. So no, Mr. President, you notice, Mr. President, I listen only to you. So, and the issue of medicinal cannabis, Mr. President, there's no need to cover. No, because the Dangerous Drugs Act take care of that. So I move on. I don't have to deal with it. So we go to number 11, Mr. President. And Mr. President, this is now I don't even have to look at my notes because Senator Bunting knows. He, like I have sat on many boards across Jamaica and elsewhere in the world. This is not something, the main job that a board has, as Senator Bunting will tell you, and if Senator Webby was here, he'd tell you the same thing. The main job of a board is to choose a good CEO. When you do that, 80% of your job is done. You don't do the rest for monitoring and audits and that kind of stuff. That's what you do. So the legislation in item 9 is very clear. Okay, so it says the chief executive officer shall be an individual who is chosen by the board and possesses knowledge. How do you get knowledge unless you're qualified? The board decides that. You don't write that in a bill. The board decides because qualifications change. Because if you read it properly, don't be misled, Senator Bunting. When you read it properly, it says the chief executive officer shall consult with and receive the approval of the board in establishing the qualifications. The qualifications, in fact, for the CEO is outlined in 2A to D. The qualifications can include anything. It doesn't say what they are. It says that CEO must consult with the board.
Clarification. I'm not saying you must set out what the qualification
Senator
is.
Brown,
I'm simply saying you must say qualification.
Senator Brown, you have a point of clarification?
And the minister yield, and I'm raising it. That's what I'm saying. I'm not asking for the specifics of the qualification. I'm saying that the person must be qualified.
Mr. President, I put it to you that that's a complete change of what was said in the beginning. So what I'm saying to you, the qualifications mentioned here are those that are to be discussed with the board, and they will be done and handled properly. And we go then to section number 11. Okay? And that section 11 takes care of what the CEO must do. So the bill provides for that very clearly, Mr. President. This matter of secrecy, the matter of secrecy, what is written here is subject to the Access to Information Act. It doesn't overrule the Access to Information Act. It's subject to it. So if you need particular confidential information, go through the Access to Information Act and you'll get it the right way. The tribunal. Tribunal is an important issue, Mr. President. And I just want to make sure that the minister will have some discretion in how he or she appoints that tribunal. I just want to make it sure and make it clear to my colleagues in this body and to Jamaica that the minister will reserve some discretion. He has to have some discretion. And of course, the matters that Senator Brown raised, the minister will take it into consideration. But he has, and that's why he has the right to appoint the tribunal. He will take advice, but you cannot dictate every item that must happen in the bill. In fact, sometimes, Mr. President, we just have to wait to make sure no bill can cover everything. We will see how it works, and then amendments or the regulations can be amended to take care of it, because we must make sure that a tribunal and the number of tribunals that exist, it's a fair question. We can answer that another time, but that need not cause this bill to be delayed. We talked about the FLA and so on. You don't want a tribunal at FLA, and we'll give you how many tribunals that exist. My staff, I'm sure, will find it and get it back to you. But you don't want a tribunal that is at the FLA to be responsible for dealing with a tribunal with drugs and so on that a tribunal at the Ministry of Health will deal with. So we'll make sure that we will give the listing, but as we consolidate, we have to take those things into consideration. The issue of management and technology, which my colleague on this side raises, is a very good one. I have been very much involved with that issue across the board. And when the board gets appointed, usually, Mr. Chairman, at the first meeting, I give a charge, and then the people in the ministry will follow. I believe the bill has been long in coming. I believe it covers what we need to do. The regulations are being finalized. Clearly couldn't be finalized before today. They're almost there, almost to be done. We will include those things that have been discussed today that will make a difference, and we can. I believe the bill is sufficiently comprehensive, Mr. President, has given enough time for review, and I ask for this body to support this bill as presented, if it pleases you, Mr. President.
Thank you, Minister. And I think that you're asking for the bill to be read a second time.
I did say so at the beginning, and I repeat it now, Mr. President, that I ask that the bill be read for the second time.
Thank you very much. The question is that the bill be read for a second time. Those in favour? Against?
A bill entitled An Act to Establish a Body to be called the National Compliance and Regulatory Authority to regulate the processes and practices connected with the manufacture, production, processing, and treatment of commodities, of which a compulsory standard specification or a technical regulation has been declared, and for connected matters, read a second time.
Thank you, Madam Clerk. The Senate will now resolve itself into a committee of the whole Senate to consider the bill clause by clause. Senator Brown, you had indicated certain difficulty. You just identify the difficulty for me so I can take. Okay. All right, okay.
3.
Okay. Members, I put clauses 1 to 3. Those in favour? Against? Ayes have it. I put clauses 4 to 16.
Sorry, you put 3?
Eh?
You put 3, I thought you were putting 1 to
You
2.
want me to read? You want to read?
Yeah, I want to at 3C.
Okay. So I'm going to, we had put clauses 1 and 2. I'm going to ask that clause 3 be recommitted. Those in favour? Against? Yes, Senator Brown. Clause 3, you had something to say?
Yeah. At 3C, regulate and enforce the process and practices connected with the before manufacturing, the import, manufacturing. So I'm proposing import be placed there.
Senator Hill, you want to just respond to that quickly for me?
Yes, Mr. President. I really do believe that. Sorry. Oh, sorry. We're not in the same. Yes, I do believe, Mr. President, that C2 does cover it. It's broad enough.
So there is a proposed amendment has been put. Now you have to listen to me carefully, you know. A proposed amendment has been put by Senator Brown to include import, correct? So that is the amendment that I'm going to put. Are you those in favor of the amendment? Those in favor of the amendment? Aye. Against? Aye. No, man, if you say no.
No.
That's why I said you must listen to me carefully,
no.
you know.
I said no, Mr. President.
Yeah. So, those in favor of the amendment? Those against? But then they must listen, you know. No, well, then they must say no. Go again. Those in favor of the those in favor of Senator Brown's amendment? Those against?
We're against it.
Okay, thank you very much. So I'm now going to no, the ayes had it. So I put clause 3 now. Those in favor of clause 3? Against? Okay, so the ayes have it. Can I put clauses 4 to 16? No, with what? 9? Okay, so let me put clauses 4 to 8. Those in favor? Clause 9. Senator Brown?
9.2, Chair. 9.2A, it says now possess the knowledge, skills. Before knowledge, I'd like to insert the words, the requisite qualification, comma, knowledge, skills. So requisite qualification is the word I am proposing to amend it. Sir? Yeah. And then continue to knowledge. That is correct. You can count. At least the St. Elizabeth teachers were good to you.
Senator Hill, you have any desire, any intention to accede into that?
No, Mr. President, and there's a good reason, because it says here that the board will require that the CEO possess the knowledge, skills, and experience. You can't have knowledge without the qualification for this job.
Well, Senator Brown, listen to me again carefully, you know. Senator Brown has put forward a proposed amendment. Those in favor of Senator Brown's, those against Senator Brown's.
Against.
Chairman, are they against Senator Brown or are they against amendment?
You notice I have to put your name in it to get a response
from them.
Someone
they're against Senator Brown or are they against the amendment?
Senator Brown's proposal has not found favor with the majority.
That's right.
So I put clause 9. I put clause 9. Those in favor?
Aye.
Against? Can I put 10, 11, 12, 13, 14, 15, 16? I put...
Go to 12 because I want to...
Okay, I put clauses 10 and 11. Those in favor?
Aye.
Against? Clause 12. Senator Brown?
13, clause 13.
Okay, I put clause 12. Those in favor?
Aye.
Against? Clause 13. Senator Brown?
Yes, Chair. At 13, I wish to add 13.4 and to say that the access to information legislation applies to this bill.
Okay, Senator Brown is asking that you specifically mention...
To the Act, yeah.
Specifically mention the application of the Access to the Information Act to this legislation. Those in favor of that proposal?
Aye.
Against?
Against.
Okay, Senator Brown's proposal, because I think that it goes without saying that it applies. So that senators, I can now put 13, 14, 15, and 16. Those in favor? Against? In part 3, I put clause 17. Those in favor? Again, no, wake up, guys. I put clause 17. Those in favor? Against? I put clause 4, that is 18 and 19. Those in favor?
Just to clarify, Chair.
Sorry.
Just to clarify, Chair, at 19. Part 4 is what he said. So, well, no, he said, I thought you said part 4. Just so I need to clarify. What is intended at 19, just to be clear, is that it is not the date of the decision from which a 14 days springs, but the date of receipt of the decision by the person who wishes to appeal. And that's what is intended.
Can I say?
Yeah.
In a situation like this, the time would run from the notification, I believe. Is that the intention?
And that's what I'm wanting to be clear, because in some case, it is from the date of the decision. And not...
You know, it is like, I think that Senator Bunting would appreciate this.
No, I support this, you know.
I'm just saying, I think Senator Bunting would appreciate this. I think this is akin to a tree falling in the forest where there is no one to hear it.
President, I don't know about Senator Bunting, but what I will say here is that it's important. This is an important issue on which judgments have been made in the court. So I want to be clear that we are intending, sorry, Pedro, let me just finish. We're intending that it is from the date of receipt of the notice.
Yes, I would say so.
Yeah, I don't think we lose anything by making it explicit.
No, it's explicit. I'm satisfied.
I would think you have recorded it. That's your understanding. That's what I've been confirmed. And the regulations can clarify that. I don't think we need to stop this.
Thank you very much. Can I put clauses 18 and 19? Those in favor? Against? Clauses, part 5, clauses 20 to 22. Those in favor? Against? Ayes have it. Clause 23. Those in favor? Against? Ayes have it. First schedule. Those in favor? Against? Ayes have it. Second schedule. Those in favor? Against? Ayes have it. You know that this process is one that is it has a reason, you know, because the Hansard has to record the majority vote, right? So if people are drifting off, it's not helping me as I go through. So lively up yourself here now. I put the third schedule. Those in favor?
And the third schedule, I beg to have my reservation, and in fact, objection recorded.
Okay, we record on the third schedule.
So, President, in the future, you will not say I voted for it.
Okay, so Senator Lambert Brown has indicated his objection to the third schedule, which the majority has agreed to. Correct? Yes. Okay. So I put the fourth schedule. Those in favor? Aye. Against? Ayes have it. I put the title and enacting clause. Those in favor? Aye. Against? The question is that I do report the bill as having passed committee stage without amendment. Those in favor? Aye. Against? I do report the bill as having passed committee stage without amendment. Minister?
Mr. President, I now ask that the bill be read a third time.
Thank you very much. Members, the question is that the bill be read for a third time. Those in favor? Aye. Against?
A bill entitled An Act to Establish a Body to be called the National Compliance and Regulatory Authority to regulate the processes and practices connected with the manufacture, production, processing, and treatment of commodities for which a compulsory standard specification or a technical regulation has been declared. and for connected matters, read a third time and passed.
Thank you very much, Minister.
Mr. President, it is not contemplated for us to do any further business today. I therefore ask that the Senate be adjourned for a date to be fixed.
Thank you very much. The Senate will now stand adjourned for a date to be fixed. Mr. Bunty, did you get my note about my informing the dining room that you're coming downstairs?
But did they tell you whether they had vegan options?
You don't know that in Jamaica, vegan option is callaloo. I'm sure. I'm sure. Eh? So the question is that the Senate be adjourned for a date to be fixed. Those in favor? Against?